In this series of lectures on Information Technology Act of 2000, almost we have discussed five important questions relating to information technology. And now we would like to discuss those important landmark judgments delivered in connection of violation of the provisions of Information Technology Act of 2000, and in that connection, first important leading case that we would like to discuss is Bennett Coleman and Company Limited, which held two domain names economictimes.com and timesofindia.com for its respective newspapers, the Economic Times and the Times of India. The Bennett Coleman and Company filed two complaints, one against Stephen S. Lalwani and the second against Long Distance Telephone Company, who had got sites registered as the economictimes.com and the timesofindia.com. The tariff to these sites, the traffic to these sites was redirected to other sites of Lalwani and the long distance telephone company. The complainant claimed that the registration and use of the domain names Y, Lalwani and the long distance telephone company was in bad faith. The defendant suggested that any misleading impression would be dispelled by the different design of the website. The court held that the defendant sites were named to take advantage of the complainant's very considerable reputation by misleading internet users. Therefore, the court ordered the two domain names stood transferred to the complainant. And the second important leading case relating to information technology is the Rediff Communications Limited had registered the domain name Rediff.com with Network Solution Inc. in February 1997. In January 1999, Shire Booth, the defendant, registered the domain name Rediff.com with National Solutions Inc. The plaintiff alleged that the defendant had adopted the word Rediff as part of its trading style deliberately to pass off its business as that of the plaintiff. The Bombay High Court considered that both the plaintiff and defendant had a common field of activity operated on the internet, provided information of a similar nature and similar facilities, such as sale of books, that chat line, and opinion polls. The court restrained the defendant from using the said domain name. And another important leading case in relating to information technology is that Yahoo Inc. versus Ashok Arora, the plaintiff who was the registered owner of the domain name Yahoo.com, succeeded in obtaining an injunction from the Delhi High Court, restraining the defendant and his agents from dealing in service or goods on the internet or otherwise under the domain name yahooindia.com or any other trademark or domain name which was deceptively similar to the plaintiff's trademark, Yahoo. And the further important leading case that would like to deal is Aqua Minerals Limited, and that the makers of the Bisleri brand of mineral water. In that case, the Delhi High Court restrained an IT company from using Bisleri.com as a domain name for its website, following a suit filed by the Aqua Minerals Limited, who are the makers of the Bisleri brand of mineral water. And now we would like to discuss some other important cases relating to information technology. So, in 2012, a freelance cartoonist, Asim Trivedi, was arrested under Section 66A of the IT Act and Section 2 of Prevention of Insult to National Honors Act 1971 and for sedition under Section 124 of the Indian Penal Code, as his cartoons depicting widespread corruption in India were considered offensive. And further, in 2012, we would like to discuss another important leading case relating to Ambikesh Mahapatra. So, Ambikesh Mahapatra was a chemistry professor of Jadavpur University, arrested for sharing a cartoon of West Bengal Chief Minister Mamta Banerjee and then Railway Minister Mukul Roy. The email was sent from the email address of a housing society. So Subrat Sen Gupta, the secretary of the housing society, was also arrested. They were charged under Section 66A and Section 66B of the IT Act for defamation under Section 500 of the Indian Penal Code for offense gesture to a women, and also under Section 509 of the Indian Penal Code for abetting a crime under Section 114 of the Indian Penal Code. And now we would like to discuss another important leading case, and that is Ravi Srinivasan's case, where he was a businessman of Puducherry, was arrested under Section 66A of the IT Act. He had posted a tweet accusing Karthi Chidambaram, son of the then Finance Minister P. Chidambaram, of corruption. Karthi Chidambaram had complained to the police regarding this matter. And now we would like to discuss another important leading case, and that is relating to Palghar's case. So, a 21-year-old girl in 2012 was arrested from Palghar of Maharashtra for posting a message on Facebook criticizing shutdown in Mumbai for the funeral of Bal Thackeray. Another 20-year-old girl was arrested for leaking the post. They were initially charged under Section 295A of the Indian Penal Code, hurting religious sentiments, and Section 66A of the IT Act. Later, Section 295A was replaced by Section 505 subsection 2, promoting enmity between classes. So, another important leading case relating to Information Technology Act, and that is Azam Khan's case. So, where exactly in 2015 a teenage boy was arrested from Bareilly, Uttar Pradesh for making a post on Facebook insulting politician Azam Khan. The post allegedly contained hate speech against a community and was falsely attributed to Azam Khan by the boy. He was charged under Section 66A of the IT Act and Section 153A promoting enmity between different religions and Section 504 which provides intentional insult with intent to provoke breach of peace, and Section 505, which provides regarding public mischief of the Indian Penal Code. So, after Section 66A was struck down by the Supreme Court on 2015, the state government said that they would continue the prosecution under the remaining charges filed under Indian Penal Code. And now we would like to discuss another important leading case, and that is Shriya Singhali's case. So, in 2015 also, another important landmark judgment was relating to the leading case of Singhal versus Union of India, where the Supreme Court held that notification to take down content should be issued through a court order. The IT Rules 2023 enables the Union government to bypass this process and address the social media intermediary directly. And another important leading case is Kaushal Kishore's case. So, as in Sri Singhal Section 66A of IT Act was struck down because it suffered from the vice of vagueness. So, in Kaushal Kishore versus Union of India in 2024, the Supreme Court ruled that these restrictions are exhaustive. So, now we would like to discuss the most important leading case under IT Act is Kunal Kamra's case. So, as per this provision here, we would like to discuss those rules framed in 2023. So, on 6th April 2023, the Ministry of Electronics and Information Technology issued the Information Technology Intermediary Guidelines and Digital Media Ethics Code, amended Rules 2023. These rules direct social media intermediaries such as Facebook, Twitter, etc. to remove any news related to the business of the central government that is deemed fake, false, or misleading by a fact-checking unit established by the union government. So, on 10th April 2023, the comedian and political satirist Kunal Kamra challenged the rules in the Bombay High Court. Kamra claimed that the formation of a the fact check unit is in conflict with Section 79 of the Information Technology Act 2000 which is a safe harbor provision for social media intermediaries. It protects them from liability for user generated content according to Section 79. Subsection 3, intermediaries must remove content upon receiving a notification from the Union Government under Rule 7 of the Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules 2021. A social media intermediary can lose its safe harbor if it does not comply with the IT rules. And in the year 2023, Karma's petition argued that broad and imprecise terms would lead to self censorship by social media users, resulting in excessive regulation and suppression of free speech. Moreover, social media intermediaries might opt to remove information to avoid the risks of losing their safe harbor and protection. So, on the very ground of restriction, freedom to carry out profession, Kamra argued that the IT rules 2023 violate his right to carry out his profession as a political satirist under Article 19, Clause 1, Subclause G. He feared that his content was likely to be handpicked by the Union government and subject to the fact check unit, potentially leading to him losing access to social media. He speculated that other political satirists will avoid political commentary, and the IT rules were challenged under the grounds violate the principle of natural justice. So the IT rules 2023 do not have any provision for a grievance redressal cell or any such platform to appeal the flagging or removal of any content by any intermediary. Camera argues that this would allow the government to flag any content critical of its actions or policies. The lack of an opportunity for users to present their case violates the right to be had under Article 14. He argued that the Union government encroached upon the domain of the courts, essentially making it the sole arbiter. And further, the response of the Union government on April 21, 2023, the Union responded to Camera's petition and termed it premature. They stated that the rules were issued in public interest to prevent the spread of false news. They argued that the fact checking unit will be carried out on the basis of evidence. Further, all aggrieved persons will have the remedy to approach a court if their information is flagged and taken down. So, in connection to continuing Kunal Kamra's case, where he alleged the violation of Article 14, Article 19, Clause 1, Subclause A, and Article 19, Clause A, Subclause G. Another important leading case entered into the periphery of information technology, that is Association of Indian Magazines and Editors Guilds of India, So, in June 2023, the Association of Indian Magazines and Editors Guild of India filed a writ petition challenging the IT rules 2023 in the Bombay High Court. These petitions were clogged with Kamra's petition. So on September 2023, the Solicitor General Tushar Mehta submitted that the fact check unit would not be notified until the Bombay High Court render its judgment. The petition was heard by Justice Gautam Patel and Dr. Nila Gokhale on 31st January 2024. The Bombay High Court delivered a split verdict. Justice Patel held that the amendment should be struck down. He objected that the fact check unit of the Union government becomes the sole authority to decide whether a piece of news or information is true or false. Anything could be said to be fact, as Justice Patel noted. Misleading is entirely subjective, and as to the truth and falsity throughout recorded human history, there are few, if any, absolute truths. Further, he expressed concern that social media intermediaries are a vulnerable segment who would comply with takedown requests due to the risks of losing safe harbor. They say argued allows the government through its fact checking unit to be the final arbiter not just of what is or is fake, false, or misleading, but more importantly, of the right to place an opposing point of view. He also pointed out that the Union government did not demonstrate how the fact check unit would go about its business. He held that the IT Rules 2023 attempts to expand the exhaustive restrictions and is contrary to Kausal Kishar and Sriya Singhal's judgments. And in her contrary opinion, Justice Gokhale held that social media intermediaries will not lose their safe harbor. She pointed out that according to Sri Singhal's case, the protection will cease to operate only if the intermediaries fail to take down information which is within the exhaustive limitations under Article 19, Clause 2. Further, she stated that an aggrieved person can address their grievances and seek remedies. This would make a competent court the sole arbitrator and not the Union government. Additionally, she noted that it was unfair to attribute bias to the fact check unit simply because it was appointed by the government. According to her, the challenge was premature as it was based on the anticipation of a potential abuse. She also stated that the IT Rules 2023 were for carving misinformations, that is, patently untrue, political satire, political parody, political criticism, opinions, views, etc., does not form part of the offensive information as it was expressed by Justice Gokhale. After the judgment, Kunal Kamra approached the Bombay High Court with an interim application seeking a stay on the notification of the fact check unit. Earlier, the Union government had given its word that the fact check unit would not be notified until the pending petitions are decided. The matter was placed before Justice A.S. Chandurkar. This application was not concerned with the constitutionality of the amendment. Justice Chandurkar held that notifying the fact check unit would not lead to an irreversible situation, as any action by the unit would be subject to the validity of the amendment, which was still undecided due to the split verdict. So on March 2024, Kamra approached the Supreme Court appealing this decision of the single judge of the Bombay High Court. So on March 20th, 2024, the Union notified the fact check unit. Uh, the, the case was heard by a bench of Chief Justice, the then Chief Justice D.Y. Chandrachud, with Justices J.B. Patiwala and Manoj Mishra. And as the matter was heard on 21st March 2024, the Supreme Court put a stay on the Union's notification establishing the fact check unit. So, all these important landmark judgments relating to Information Technology Act of 2000 and the subsequent rules made by the Union government in 2011 or in 2021, and finally the 2023 rules were challenged in violation of freedom of speech and also regarding freedom to carry any profession or occupation, trade, or business, as it was a matter falling under Article 19, Clause 1, Subclause A, and Article 19, Clause 1, Subclause G, and also the violation of the principle of natural justice, as under Article 14, as it was challenged by Kunal Kamra. So finally, in 2024, on 21st March, the Supreme Court, under the deciding bench of Chief Justice D.Y. Chandrachud with Justice J.B. Patiwala and Manoj Mishra, put a stay on the Union's notification establishing the fact check unit.